I just want to make two brief statements about the process that we engage in here for judicial nominations. I want to say, first of all, that I'm very glad that none of the nominees today have blue slip problems. I do think that it is a very significant mistake for this committee to have gotten rid of the tradition of the blue slip for circuit court nominees. As I've said before, the convention that circuit court seats are associated with a particular state is one that has no foundation either in statute or in the Constitution. It is a tradition that develops in the Senate, and that's really the only mechanism for enforcing it. Ms. Grant was introduced here by two friends of ours, by Senator Isaacson and Senator Perdue, for whom we have the highest regard. And the reason that they did is because it is accepted that her seat on the 11th Circuit Court of Appeals is a Georgia seat on the 11th Circuit Court of Appeals. But if there is no blue slip that enforces the right of those two senators to assure that this remains a Georgia seat on the 11th Circuit Court of Appeals, there is nothing that prevents a future president from deciding that instead of Ms. Grant, it could be somebody from Alaska or California or Massachusetts or any place else. I think we take on the traditions and conventions of the Senate with regard to judicial nominees at our peril, and I think we will rue the day that we gave up the blue slip or stopped honoring the blue slip for circuit court nominees. Again, I'm happy that that is not an issue with this particular nominee, Mr. Chairman, but I do want to flag this as a recurring problem. The other recurring problem that I see is the extent to which special interests are heavily engaged in the pre-selection process that the Trump administration maintains, with the raising the suspicion that in some cases they have to demonstrate fealty to those interests before they can get into a place where the president will nominate them. Again, I don't think that's true for all nominees. In many cases, the president has worked very well with the senators who have some authority over this to try to make sure that qualified nominees get through. But as you know from the statement I made the other day with respect to the nominee Oldham and the newly confirmed Judge Ho, I've got some very grave concerns about the extent to which people are being plugged into that judicial nominations machinery with a view to having them, once on the court, be predisposed in favor of certain big, powerful interests. Welcome, Judge Grant.
Thank you.
What do you suppose is the most important thing that a litigant or a party walking up the steps to the courthouse on the day of their trial or argument ought to be able to feel about what they have ahead of them that day?
I think a litigant ought to be confident that the judge or judges who are considering their case will treat them fairly, won't make a decision based on who the litigant is or who their opposing party is, won't make a decision based on any personal policy preferences or ideas, and won't have prejudged the case before it even got to them. That's something that I've committed to do as a Georgia Supreme Court justice, and it's something that I would also commit to do on the 11th Circuit if I were able to serve there.
If the judicial system were to get into the practice of rendering decisions based on the identity of the parties rather than the merits of the case, how consistent would that be with the American system of justice compared to, for instance, the system of, quote, justice, close quote, in banana republics?
That would be completely antithetical to the way that we decide cases here in the United States, both at the state level and at the federal level. For my part, I decide without reference to who the identity of the litigants are. That's not part of the question. The question is, what is the law, what are the facts, and how does the law apply to those facts?
Now, you were a Solicitor General, not a trial practitioner, but you obviously were defending a lot of trial cases, and as the Supreme Court judge in Georgia, you're overviewing Supreme Court trials. I'd like to hear your thoughts on the role of the jury, and I will show my bias in this sense, or my point of view in this sense, by pointing out that some of the leading commentators on American government and law have defined the jury as something more than just a mere fact-finding appendage of a court, but actually an important element of our constitutional structure of governance. And I'm wondering what your view is with respect to that question.
I couldn't agree more. That's one of the most...
With which?
With the fact that the jury is an important part of our constitutional structure.
Not a mere fact-finding appendage of a court.
I believe, as we can all see, the right to a jury is specifically included within the Constitution. And the jury's decision-making is protected. The jury's role is sacrosanct in many instances. As a judge on the Supreme Court of Georgia, I know that jury verdicts are jury verdicts. We, as the court, do not review whether a jury got a question right. We review whether there were legal errors that were at issue in a particular case. The jury's role is a crucial one. And I will say, although I've been an appellate practitioner most recently, in the beginning part of my career, I was a trial attorney at a firm here in Washington, D.C. And although none of my cases ever went to trial, I certainly did engage in all of the pretrial discovery, depositions, witness interviews, all fact expert discovery. So I'm certainly familiar with I've been involved in the trial aspect as well as the aspect of the judicial system here. And that's deepened my appreciation for the jury as well.
I think it is not unheard of that an executive branch policy decision is made based on the interests of powerful political forces, and clearly it is not uncommon for legislative decisions to be made based on the interests of powerful political forces. Is there any role for political power or influence in the courthouse?
Not in my courtroom, sir. As I've expressed, each case needs to be decided without respect to anything else going on outside of the case. Each case is decided without respect to the persons involved in the case, to their identities, to whether they're rich or poor. That's part of the oath that I've already sworn as a justice on the Georgia Supreme Court, and that's certainly what I put into practice.
Indeed, isn't it the case that the Founding Fathers specifically set up courts and within courts juries as kind of a relief valve for circumstances in which powerful special interests control the legislature or control the governor's mansion, and a regular person opposed to them can't get a fair hearing, but there's still the courtroom. Isn't that part of what we set up as we set this country in its constitutional path?
I think there are many reasons that the jury is an important actor in...
Is that one of them?
I expect it's likely to have been one of them.
Mr. Wyrick, you are the recipient of the most stunning rebuke I've ever heard in the United States Supreme Court when Justice Sotomayor said to you, "I am substantially disturbed that in your brief you made factual statements that were not supported by those sources that you had cited, in fact, directly contradicted. So nothing you say or read to me am I going to believe, frankly, until I see with my own eyes in the context, okay?" How on earth, I've argued in the Supreme Court, how on earth do you not check and recheck your citations to make sure that you are not making false statements to the Supreme Court?
Senator Whitehouse, I certainly stand by the citations we made in that brief, and ultimately,
So she was wrong.
She was mistaken with respect to the particular scientific evidence that we had cited. This was I certainly sympathize. That's the purpose of argument is to sort these things out. I think if you look at her written opinion in the case, and she certainly filed a passionate dissent, there's no mention of those disputes about the evidence, because I think upon close consideration, the things we cited did support the conclusions we made in the brief. And certainly that was the position of a federal district court, a unanimous panel of the 10th Circuit, and the United States
So
Supreme
your answer is that she was mistaken. Let me go on to another episode where it appears that you shopped out the seal of the state of Oklahoma to a special interest lobbyist for a donor company. The fact pattern is that Devon Energy directly emailed you a draft letter in 2011 that the Attorney General you then worked for, Mr. Pruitt, took, and after changing just 37 words out of 1,016 words, copied it onto Oklahoma state government letterhead and sent it in to the EPA administrator as if it were the work of the Attorney General's office. Afterwards, the lobbyist emailed you, "Outstanding. Please pass along Devon's thanks." That, I guess, was a happy enough experience for them that the same lobbyist tried it again in another email attaching another draft letter for Mr. Pruitt, hoping that he'd be comfortable sending that letter to the acting director to whom the letter is addressed. Again, your response provoked the lobbyist replying, "Wonderful." At the time that incident took place, were you aware that Devon Energy was a substantial donor to Mr. Pruitt's political enterprises?
I don't recall. I didn't recall the particular email that you're referencing until it was brought to my attention a couple days ago. As best I can recall, someone emailed me a draft letter. I'm a litigator. I handle litigation issues. I would have passed it on to the appropriate person in the office who would have reviewed it, and then action on that letter would have been taken by those people in the office. I don't have a specific recollection.
So the fact
of
that it
letter
was you who the lobbyist got back to say, "Wonderful," how do you reconcile that with what you just said?
My understanding, and this is going back to, I had to go back and refresh my memory on this, is that ultimately the EPA agreed with the position that the Office of Attorney General took in the letter.
Yeah, I'm less concerned about the EPA position than about what it means when a staff member for the Attorney General is coordinating directly with lobbyists to, as I use the phrase, shop out the seal of the state of Oklahoma to a donor. Were you a shareholder in Devon Energy at the time of that?
No, I was not.
Okay, that happened since?
I've held shares in Devon at times. I don't now. As a judge, I've divested myself of shares in individual companies.
Okay. More generally, given your record on environmental issues, I wonder how you could expect anyone representing the EPA or an environmental organization to feel they would get a fair shake in your courtroom. You've even said that you think the entire administrative state is unlawful. How can you unthink that if you think that the entire administrative state is unlawful?
Respectfully saying, I don't believe the entire administrative state is unlawful.
September 16, 2016, you to the George Mason Law School.
Yes, we were talking about arguments that we make in favor of standing in environmental cases, and that was one of the arguments that as an advocate litigating on the behalf of the state of Oklahoma, we would make in support of standing, arguing that there were certain constitutional flaws, delegation.
So you would argue on behalf of the state of Oklahoma a concept that you did not believe to a court, namely that the entire administrative state is unlawful, just to make a point about standing?
No, Senator, and I don't recall ever making that argument to a court.
Okay. Well, my time has expired. I think we're going to have a lot of follow-up here with respect to questions for the record and so forth, particularly with regard to the claims that Mr. Wyrick has made about where he lived and when he lived there in the pursuit of residency in the district that he was elected to. So my time has expired on that. If we're going to have a second round, I'll follow up with that. But if not, I hope that the chair will indulge the importance of the questions for the record in this particular case.
If you want a second round, go ahead.
Well, let me ask you, in October of 2016,
Five more minutes.
the seat that you occupy now opened up. You were living then in a different county. You registered for the first time in the county where your seat opened up 2 months after the seat opened up, and you then filed papers claiming that you had domicile in that country, in that county. Where were you actually living in October of 2016?
In October of 2016, and for many years, I've lived and worked in Oklahoma City. That's where my job requires me to be.
And your wife lives there as well?
Yes.
And your kids live there?
Yes, sir.
And they go to school in Cleveland County?
Yes, they're in Cleveland County.
And in the previous election to October of 2016, you were registered to vote in Cleveland County. And you voted in the primary in Cleveland County.
I believe that's correct, yes.
Since then, where do you live right now?
I live in Oklahoma City, Oklahoma.
Okay. All right. Well, we'll follow up then. Thank you very much.
I won't repeat what I said.
Just for the record, I'm sorry, Mr. Chairman, but because everybody doesn't know the geography, Oklahoma City is in Cleveland County,
Oklahoma County.
mostly.
Yeah, there's a little
Have I
bit.
got
of
the
Cleveland
geography
County.
right?
So, yes,
Okay.
partially.
So you are living in a place that is not in the district that you are elected from right now,
I'm not elected, I'm appointed.
appointed from right now.
Yes, and there's no requirement that I live in the district that,
Okay.
that I represent.
Thank you.